Court does call the case of People versus Gary Carmichael.
And then on behalf of people,
Assistant Public Defender Natalie Pate with and on behalf of Mr. Carmichael, who stands to my right. Please state your name for the record, sir.
Gary Walter Carmichael.
Excuse me one moment. I don't have the motion.
Let me grab it for you.
All right. This is the people's motion. They're just bringing the paperwork. This is the people's emergency motion regarding bond.
yes, Your
So
Honor.
go ahead.
Just to start, the defendant was arraigned on January 3rd and was given a PR bond, which you guys have a no alcohol tether. Despite our request for $25,000 surety bond, as you guys tether and an alcohol tether. The events in this case stem from an incident between the defendant and his partner and the mother of their 2-year-old child. On that day, the defendant had been drinking. And the victim described that he consumed a pint of liquor and 2 12-way alcoholic beverages before this incident. And initially they had a verbal dispute that escalated into physical violence. And in that, the defendant originally took the victim's phone and threw it against a wall. He then proceeded to go to his gun safe and start digging around in the gun safe. Then he returned to the victim, charged at her while she was on the couch and held her on the couch and proceeded to strangle her. The victim described the defendant trying to strangle her 4 times and ultimately punching her in the face. She also reported to officers that there had been multiple incidents that involved domestic violence that she never reported, including an incident where he picked her up by the throat and threw her against a wall. During this incident, she was pregnant at the time. I also concerns officers noticed injuries consistent with her statements, including strangulation marks, a busted lip, and blood on her shirt, as well as furniture being out of place in the residence, table being turned over. At the time of this assault as well, there was a child asleep in the home. So I have concerns for her safety, the community safety, and I believe that the original bond as set was an abuse of discretion, given that he, in previous criminal history, does have convictions related to drinking. So I would have concerns that he was not given an alcohol tether. I would ask that for the court to send his bond at our $25,000 surety bond with the GPS tether as well as an alcohol tether, given the seriousness of this case and the charges the defendant is facing.
Ms. Pate.
Thank you, Your Honor. Ultimately, we are asking that the court keep the monetary amount the same, being a PR bond. I do want to note that my client has had the GPS tether placed on him, and he does have no objection to an alcohol monitoring device of any kind being added as a condition of bond. Further, if the court would also like any sort of drug or alcohol testing apart from a scram or SoberLink tether, my client would also be willing to do that as well. To my understanding, since the time of his arraignment and now, again, only being a couple of days, nothing has changed, and I do not believe there is any sort of bond violation or contact the complaining witness alleged since his arraignment or, quite frankly, his arrest. My client does have an address in Northville where he stays with his 2 children that are not with the complaining witness. His kids are ages 10 and 14. I do have this address in Northville. The complaining witness does not live there. He completely understands the conditions of bond of no contact and no go-to. It is my understanding the complaining witness lives in South Lyon, far away from this Northville address, and that she resides with their 2-year-old.
Define far away.
Not within the same block or neighborhood or anything like that. Obviously, it's within the same state. Northville being far or a distance from South Lyon. It is further my understanding.
They're actually relatively close at points.
I'm not going to go anywhere near.
Well, I'm just trying to figure out the distance between the 2 because
It's like probably 10 miles.
yeah, relatively close. All right, go ahead.
Okay, so 10 miles or a completely different city away from where he would live. He does not live with the complaining witness. We do acknowledge they do have a 2-year-old child in common. It is my client's understanding that that 2-year-old child is now staying with the complaining witness at that South Lyon address with the complaining witness and her mother. He completely understands the need for no contact order. He states to me he's willing to do anything in order to stay out of custody. He does have full-time work at a construction company. I won't put the name of the company on the record, but he does do that in home remodeling, and he's been there about 6 or 7 years. To my understanding, this is his only pending criminal matter of any kind. Further to my understanding, at the time of this alleged offense, he was not on probation, parole, or bond in any other matter. To my understanding, his most recent prior conviction was a 2013 drinking driving conviction, so about 12 or 13 years ago at this point. Miss Anderson from our office has been able to speak to my client's sister directly and was able to confirm where the kids are currently staying with their mother. Again, his GPS tether is,
His kids.
yes, his 2 children are currently staying with their mother, who is not the complaining witness. Again, he is not asking for any contact at this time. I won't comment on the actual allegations of the case itself, given I haven't even had the opportunity to review a police report or anything of that nature. But I will note that my client does deny these accusations and states that there is a lot going on. He does understand his bond conditions, especially the no contact, no go to order. And he understands that, quite frankly, if there's any sort of whiff of bond violation or contact or text or anything, he would be right back in custody. And he does not want to do that. And this is his only pending matter, Your Honor. So we would ask that bond remains the same. Of course, he has no objection to an added condition of the Scram tether or Silverlink.
Well, how does he plan on, to the extent he does, caring for the 2-year-old? Or his participation in that?
So usually I have full custody of my 2-year-old because of her situation that she's going through. She has a mental illness and has been in and out of rehab multiple.
See, hold on a moment. I don't know that you want to go there.
Me?
If I may, Your Honor, my client indicates to me that typically the 2-year-old does reside with him at his Northville address. His older 2 children is not in common with the complaining witness, and they reside with him. Their 2-year-old child often does reside with my client as well full-time. At the time of this offense, the 3 of them were together, and it is his understanding that the 2-year-old is still with the complaining witness right now. Initially, he was wanting to request third-party contact so he can still have contact with the 2-year-old, but at that stage, he understands if the court would not be comfortable with that.
Yes.
So I guess this allegedly occurred at her residence?
My residence.
Okay. Do you have firearms there?
Yes. I have old, like, hand-me-down, like, broken BB guns from when my dad passed away.
Yeah, BB guns in a gun case?
Yes, Your Honor. And I was able to speak to Miss Apple, who was his attorney at arraignment, and who he understands as a condition of bond, if and when released, he would have to turn those over to the, Northville Police Department or the Sheriff's Department, whatever would be closest to his
Are they
address.
just BB, or I shouldn't say just, but are they BB guns or we got something else?
My client is indicating just that, Your Honor.
How many?
3. And then, like, 4, it's in pieces.
What a courtroom
They were,
roller
like,
coaster.
from, like, the
2
30s
different
and 40s. They're
defendants,
just
2 very different
from when my dad
situations,
passed away
but
in
one
06.
consistent theme. The court is always balancing risk versus rights. In the first case, the focus was public safety, alleged violence, and control. In the second, it shifted to accountability, probation violations, and even something as
Since it
human
was
as a
brought
father
up
wanting to call his
At
child.
least in terms of
And that's
the
what makes
motion
these
brought up
hearings so
in
compelling.
argument.
Behind every legal argument is a real-life story,
The
messy, emotional,
nature
and
of the
complicated.
altercation
But
was
I'll leave you
because
with
of the
this.
pregnancy?
Do you think the system got it
Is
right in
that-
both cases, or did one of these decisions go too far or not far enough? Drop your thoughts below, because in cases like these, there's always more than one side to the story. And here it comes, the moment everything has been building toward. The judge is now
Got it.
weighing 3 key factors: severity of the allegations, prior history, and risk to the victim and community. That's the holy trinity of bond decisions. Notice how the tone shifts here. This isn't discussion anymore, this is decision mode. And when a judge says the original bond may have been an abuse of discretion, that's a big deal. That's essentially saying, the system got it wrong the first time. So now ask yourself, is this about punishment or prevention? Because what happens next will tell you exactly how the court sees this defendant. Okay, now this part gets really interesting and a little risky for the defendant. Anytime weapons or
There's only
even
one
potential weapons enter the
alcohol-related
conversation,
offense?
the stakes go up instantly. Even if these are just
Or
old BB
does he
guns, the
have more?
prosecution already mentioned a
One
gun
conviction
safe
from
earlier.
2017
That creates
for
a
an
perception
operating while
issue.
intoxicated.
And in
There's
court,
the
perception can be
conviction
just as
for a
powerful as
dismissed
reality.
operating while
The judge
intoxicated
isn't
from
just asking what the
2016.
weapons are, he's asking, should I be worried? And here's the twist. The more the defendant explains, the more room there is for inconsistency. So let's think about it. Do you
Well,
believe
since
these
it was
details
brought
help his
up,
case or
and
quietly
at
make
least
things
in
worse?
terms of the motion brought up in argument, um, the nature of the altercation was because of the pregnancy? Is that,
If I just have one moment, Your Honor. They started, in the report, it mentions they started to have a conversation about life in the future, and that's when everything took place.
got it? There's only one alcohol-related offense? Or does he have more?
There was one conviction from 2017 for an operating while intoxicated. There's the conviction for a dismissed operating while intoxicated from 2016, a 2014 reckless driving conviction, and then a 2013 conviction for operating minor with any VAC.
And the 2013 one was the only one I was aware of, Your Honor, and it sounds like the 2016 one was dismissed.
So we have a more or a closer one to today's date of an operating while intoxicated, right?
Correct, Your Honor. That's from 3/30/2017 out of the 1483 District Court. They did a preliminary breath test in this case, and I believe it was at a 0.189.
If I may, Your Honor, my client has zero objection to any sort of alcohol, scram, or sober like being added.
Anything.
Anything else from either side? All right.
Nothing additional, Your Honor.
What I'm gonna do in this case is how large is this gun safe that you have?
How large is my gun safe? Like, it's really mostly for paperwork. It's not big at all.
So would you say it's 2 feet, 1 feet?
Yeah, probably like 2 feet by 3 feet.
Is it an actual gun safe or is it something else?
It's an actual gun safe. Well, it's more of like a lock container, like a locker with a pin code on it.
Was was there medical treatment that needed to be provided to the victim?
For the report, she refused to seek medical treatment from the incident, but had the injuries the officers observed on her that we mentioned before.
What a courtroom roller coaster. Two different defendants,
Yeah.
two very different situations, but one consistent theme. The court is always balancing risk versus rights. In the first case, the focus was
was
public
able to discuss
safety,
the alleged
alleged violence,
violations
and
with Mr.
control.
Bond Sanders
In the
as
second, it
both
shifted to
cases.
accountability,
We do
probation
acknowledge that there
violations,
are those
and
new
even
pending
something as
cases.
human as a father
As
wanting to call his
the
child.
actual conduct itself,
And that's what
we
makes
are not
these
going to be
hearings so
admitting to, of
compelling.
course, the
Behind every
underlying
legal
criminal
argument
conduct,
is a
but we do
real-life story,
understand that those
messy,
cases are
emotional, and
pending
complicated.
and would respectfully
But I'll leave
request
you
that
with
the
this.
court
Do you think the system got it
consider
right in both
adopting
cases?
that
Or did one
admission
of these
and adopting
decisions
the
go too far
recommendation
or not far enough?
as to both cases.
Drop your thoughts below,
You're
because in
talking so
cases
that we're
like
clear
these,
on
there's
case
always more than one side to the story.
0803 and 25.
And here it comes, the moment everything has been building
Yes, Your Honor.
toward. The judge is
Ms.
now
Blair,
weighing
did you have
three
something
key
you wanted to
factors:
say?
severity of the
Your Honor, just
allegations,
that
prior
Mr.
history, and
Sanders
risk
is
to the
before
victim and
court,
community.
for two
That's the holy trinity
cases
of
for
bond
violations of
decisions.
probation.
Notice
He
how the
does
tone
have,
shifts here.
three
This
new
isn't
pending
discussion anymore, this is
cases,
decision
two of which
mode.
being
And when a
felonies,
judge says
all
the original
involving the
bond may have
same
been an abuse
victim.
of discretion, that's a big deal.
And there's
That's
alleged
essentially
use of
saying
assaultive,
the system
threatening, or
got it wrong the
intimidating
first time.
behavior on those dates.
So now
and
ask
an
yourself,
alleged violation
is this
of the
about
no
punishment
non-consensual
or
contact
prevention?
order with the
Because what
victim in
happens
this
next
case.
will tell you exactly how the court
Other
sees
than
this
that, Your Honor,
defendant.
the recommendation has
Okay,
to
now
both
this
cases
part
is
gets
the
really
same,
interesting
that his
and a little
probation be
risky for the
revoked,
defendant.
93 days in
Anytime
jail with
weapons
credit
or
for
even
81
potential
days that he
weapons enter the
served to date,
conversation, the
that he
stakes go up
served the
instantly.
balance,
Even if these are
and
just
waiving
old BB
remaining
guns, the
terms except as
prosecution already
financial
mentioned a gun
obligations and
safe
discharging
earlier.
from probation
That
without
creates a
proof.
perception issue. And in court, perception can be just
I
as
will
powerful
accept
as
the
reality.
defendant's
The judge isn't just
admissions
asking what
for
the weapons are,
violations, of
he's
course not.
asking, should I be worried?
Recognizing he's not admitting
And
to
here's the
underlying,
twist. The more the defendant
factual
explains, the more
elements.
room
Able to
there is for
discuss the alleged
inconsistency.
violations with
So
Mr.
let's
Bond
think about it.
Sanders as to
Do you
both
believe these details
cases.
help his
We do
case or
acknowledge that
quietly
there
make
are
things
those new
worse?
pending cases. As to the actual conduct itself, we are not going to be admitting to, of course, the underlying criminal conduct, but we do understand that those cases are pending and would respectfully request that the court consider adopting that admission and adopting the recommendation as to both cases.
You're talking, so that we're clear, on case 240803 and 250933.
Yes, Your Honor.
Ms. Clara, did you have something you wanted to say?
Your Honor, just that Mr. Bond Sanders is before the court for two probation cases for violations of probation. He does have three new pending cases, two of which being felonies, all involving the same victim. And there's alleged use of assaultive, threatening, or intimidating behavior on those dates and an alleged violation of the no non-consensual contact order with the victim in this case. Other than that, Your Honor, the recommendation as to both cases is the same, that his probation be revoked, 93 days in jail with credit for 81 days that he served to date, that he served the balance, and waiving remaining terms except as financial obligations and discharging from probation without proof.
I will accept the defendant's admissions for violations, of course not, recognizing he's not admitting to the underlying factual elements regarding charges, but there are other behaviors. Is there anything you want to say before I impose that?
I'm sorry.
On each of these cases, I'm going to revoke the defendant's probation. On each case, I will sentence him to 93 days in jail, credit 81 days, serve the balance, or credit 81, serve. Defendant is to serve the balance. I will also, on each case, waive remaining terms except financial obligations, discharge him from probation without improvement. And on the remaining case.
Yes, Your Honor. On the remaining case, the 2511892,
Yes.
that was set for today for a bond violation hearing. The case itself is already set for jury final settlement conference in February. Given the fact that this alleged bond violation has then, gave way to new cases, we are asking if the court would consider adjourning this bond violation to the final settlement conference date or a day prior to that.
All right, so I guess.
Some people would have no objection, Your Honor. I was also going to ask for an adjournment today as our officer in charge was in the hospital as recently as last night with pneumonia, so.
Okay. Well, then what I'll do is I'll adjourn the bond violation hearing to a special time on February 6th, 2026. I'll make that at 9:30. just so we separate it out from the other hearings. All right,
Thank you.
on this matter, we'll continue as revoked. Thank you.
Oh, Your Honor, sorry, I completely forgot something. Mr. Bond Sanders, when I met with him earlier today, made me aware that he believed or his phone privileges are revoked. I didn't at least have a note in my files as to these 3 cases that they had been revoked, and I didn't know if Your Honor had any information as to that. I could also then try reaching out to the jail as well. Sorry about that.
Yes, on case 25933.
Oh, okay.
I had revoked his phone privileges as far back as July of 2025.
Okay.
On that case, and then that looks, I don't see it in the other one. That was the other case I had revoked it back in July.
Your Honor, with that information, I do have a request. I would ask if the court would consider reinstating his phone privileges. To my understanding, obviously that happened back in July prior to his current remand. I did have a conversation with him again this morning. He understands the no contact order. He is asking largely so that he can have contact with his daughter. She does have some health issues. That's not the sole reason why he wants to have contact, but he's asking if the court would consider reinstating his phone privileges at this time.
Any response from people?
Your Honor, I haven't seen any violations of the no contact order through jail calls, so I would just leave it in the court's discretion.
All right. That. Go ahead. You want to say something?
Yeah, I just want to say, I have a 4-year-old daughter that has epileptic seizures, and my mother is also dealing with heart issues too. She just was in the hospital just this past Christmas. I just want to at least be able to reach out to them to at least get everything going.
Since I only revoked it on that one case, by its own terms, once he finishes that sentence, they should be reinstated. If it's not, then the court will inform the jail of that.
Excellent.
Follow that?
Yes.
So in about 10 days, you'll,
Okay, 10 days.
well, thereabouts, maybe 12.
Okay, I'm fine with that.
All right.
Yes, and thank you.
Thank you, Your Honor.
If it doesn't happen, Brown Sanders, if it doesn't happen, let your attorney know so they can get through to me.
Okay, I will. Thank you so much.
Thank you.
What a courtroom roller coaster. 2 different defendants,
Don't
2 very
see
different
any other
situations,
one.
but one consistent theme. The court is always balancing risk
That was
versus
the other
rights.
case I had
In the
revoked
first
it back
case,
in
the
July.
focus was public safety, alleged
Your Honor,
violence, and
now with that
control.
information,
In the
I
second, it
do have a
shifted to
request.
accountability,
I would ask if the
probation
court would consider
violations, and
reinstating
even
his phone
something as human
privileges.
as a
To my
father
understanding,
wanting to call
obviously
his
that happened,
child.
back in July.
And that's
prior
what
to
makes
his
these
current
hearings so
remand.
compelling.
I did have
Behind
a
every
conversation
legal
with him
argument
again
is
this
a real
morning.
life
He
story,
understands
messy,
the no
emotional, and
contact order.
complicated. But
He
I'll
is
leave you
asking
with this.
largely so that he
Do you
can
think
have
the system
contact
got
with
it
his
right in
daughter.
both
She does have
cases?
some health
Or did one of
issues.
these decisions
That's
go
not
too
the sole
far
reason
or
why
not
he wants
far
to have
enough?
contact, but he's asking
Drop
if
your
the court
thoughts
would
below,
consider
because in cases
reinstating
like
his phone
these, there's
privileges at this
always
time.
more than one side to the
Any
story.
response from people?
And here it comes, the moment
Your Honor, I
everything
haven't
has
seen
been
any
building toward.
violations of the no
The
contact
judge
order
is
through
now
jail
weighing
calls, so I
3
would just
key
leave it in the court's
factors:
discretion.
severity of the
All right.
allegations, prior history,
That-
and risk to the victim and community.
Go ahead. You want
That's
to
the
say
holy
Yeah, I just
trinity of
want to
bond
say, I
decisions.
have a 4-year-old
Notice how
daughter
the
that has
tone shifts
epileptic
here. This
seizures,
isn't
and my
discussion
mother
anymore,
is
this is
also dealing with
decision
heart
mode.
issues too.
And when a
She was
judge
in the
says the
hospital
original bond may have
this
been an
past
abuse of
Christmas.
discretion,
I just want to at
that's a
least be able
big
to
deal.
reach out to them.
That's
to
essentially
at
saying
least
the
get
system got it
everything
wrong
going.
the first time.
Since I only revoked it on
So
that
now
one
ask
case, by
yourself,
its own
is this
terms,
about
once he
punishment or
finishes that
prevention?
sentence,
Because what happens next
they
will
should
tell
be
you exactly
reinstated.
how the court sees
If
this
it's
defendant.
not, then the court will.
Okay, now
inform the
this part
jail.
gets really interesting and a little risky for the defendant.
Follow that?
Anytime
Yes.
weapons
So
or
about
even
10
potential
days,
weapons enter the
Okay, 10
conversation,
days.
the stakes go
Well,
up instantly.
thereabouts,
Even if these are
maybe
just
12.
old BB
Okay,
guns,
I'm
the
fine with that.
prosecution
All right.
already
Yes,
mentioned a
thank you.
gun safe
Thank you, Your
earlier.
Honor.